do have a caller on the line. Jane from Chipley. Go ahead with your question, please.
What is the recourse against a hospital or a doctor when they throw you out of the hospital and refuse to take care of you?
Okay, Jane, it's kind of a broad question, and sometimes doctors, they get a very bad rap, or even medical facilities get a bad rap for basically bad bedside manner. I may have just cut you off, so I think you had a second part to the question. Go ahead, I'm sorry.
What is the recourse after you have the hospital investigated and the doctor investigated by the state of Florida, and they tell you that the doctor committed malpractice in writing?
That he did commit malpractice or did not?
Yes, they put it in writing that he just misdiagnosed me.
Okay, so two parts to the question. What I was talking to you earlier, some doctors have very poor bedside manner, and it doesn't mean they've done anything wrong because they haven't breached a standard of care. But in your situation, if they have removed you from the medical facility, which has caused a malpractice issue to occur, and that either facility or that physician has breached the standard of care, and after an investigation from the state that has been deemed to have happened, I think you need to seek an attorney and a law firm that handles medical malpractice cases like our firm, so you can talk further in detail. And I don't want to ask you these questions on the air for just personal reasons, but you can call us tomorrow. We'd be glad to talk to you off the air about what situations happened and what kind of damages you or your loved one sustained as a result of their actions. But typically speaking, you don't have those letters, Ted. You don't have those condemning letters from a state agency that says somebody has committed malpractice on behalf of a facility or themselves against an individual. Typically speaking, we have to go dig that up and prove that in court.
And Jane, a couple of very important points there. You mentioned medical malpractice. It's a little different than other forms of negligence in the state of Florida. It has a shortened 2-year statute of limitations. Typical negligence cases are a 4-year statute of limitations. So for that reason alone, it's very important that you act sooner rather than later. But something that Chris alluded to, in order to actually pursue a medical malpractice case in the state of Florida. In addition, it sounds like you have some evidence from a state agency already confirming that there may have been medical malpractice in your particular situation. But in order to actually pursue that claim, you're going to have to get an affidavit from a doctor in that same specialty as the physician that did the misdiagnosis or committed the malpractice, setting forth in writing why it was malpractice and what the standard of care was that was breached. And so for that reason, you want to get on that and get that process moving sooner rather than later. Time is really of the essence in a case like this, so please make sure you reach out to us or someone like us as soon as possible.
Yeah,